On November 19, government MPs on the crime file held an unexpected press conference that suggests the government is looking to pull lawful access back from the grave. This press conference was full of misinformation and half-truths about the current state of the law and the government's proposals. So you may recall that the government introduced Bill C-2, called the Strong Borders Act, as its very first substantive bill in Parliament following the recent election. It seemingly came out of the blue, and it proposed changes to the law related to law enforcement and national security access to information. And these were roundly condemned. Now, as a result, the bill has languished and has not even been referred to committee. In another strange move, the government tabled a new bill, Bill C-12, that essentially was the Strong Borders Act, but without the lawful access parts. Apparently this was done so they could fast-track the other parts of Bill C-2 through Parliament. The newer Bill C-12 is currently being considered by the House of Commons Standing Committee on Public Safety and National Security. Most of us assumed that this was the end of lawful access, but apparently not. Earlier this week, Public Safety Minister Gary Anandasangre, Transport Minister Steve McKinnon, and Secretary of State for Combating Crime MP Ruby Sahota held a press conference defending lawful access and calling for the Conservatives to just get on board. If it hadn't been for Michael Geist's eagle-eyed attention to this topic, this press conference might have been completely missed. The full press conference is on YouTube, and I'll link to it below. The press conference was filled with misinformation about their own proposals and about the current state of the law. There are some things in that bill that are defensible, but it seems the Liberals just can't get out of their own way. Now, having watched the press conference a couple times, it was like they really don't know much about their own bill or how law enforcement actually currently operates. Everything said in the press conference seemed to relate to the provisions in Part 14 of Bill C-2, which are principally new demands and orders for customer information. I didn't hear anything at the press conference that was said that was a clear reference to Part 15 of Bill C-2, and that part would create a whole new law called the Supporting Authorized Access to Information Act. And what's also weird about this is that the politicians who were there are all associated with the Department of Public Safety. And we're told the Department of Public Safety is the author of Part 15 of the bill. Part 14 of Bill C-2 was written by and is the responsibility of the Department of Justice, which was completely absent from the press conference. The press conference was full of confused political puffery, and some statements were entirely incorrect and would lead a viewer misled. They accused others of engaging in dispensing misinformation, which is just rich. They repeatedly said that the new tools for law enforcement have judicial oversight. Here is Secretary of State for Combating Crime, Ruby Sahota.
They have also made it extremely clear that these tools are not warrantless surveillance. They are used with judicial authorization and clear legal thresholds, including modernized production and preservation orders, clarified duties for surveillance providers, and access to basic subscriber information only on judicial order with.
I assume instead of surveillance providers, she meant to say service providers.
C-2 gives police the tools they need with oversight Canadians expect: judicial authorization, clear legal thresholds, strict limits on what can be accessed and when, and no warrantless surveillance, full stop.
The warrantless information demand is just that, no warrant, no judicial authorization required. They said that we're just talking about getting customer names and addresses, so no big deal.
We're trying to connect phone numbers to names and addresses, and then judicial authorization would have to get involved even further in order if that person was a suspect and we needed further information. So it's not about encrypted, data or information. It is about connecting a name or an IP address to a phone, an IP address or a number to a name and an address. That's all this is about.
This is also incorrect and significantly misleading. Customer names and addresses from telcos are certainly in scope, but these provisions are not at all limited to telcos. This applies to anyone who provides services to the public. Do you know who else provides services to the public? Your doctor. It can be used with telcos, and it can be used with your doctor's office. And it's not limited to just customer names and addresses. It creates the mandatory disclosure of all subscriber information, And that's defined in the Act so broadly that it includes all information that the subscriber or client provided to the person in order to receive the services. Yeah, that's the medical history form you filled out when you first visited the clinic. It would include the types of services the clinic provided to you and information about any specialists you were referred to. The scope of this is simply breathtaking. Now, it does require judicial authorization, but with the lowest burden of proof our legal system has. Something, just more than a hunch. Reasonable grounds to suspect. And the judge can't say, hey, all you need is a name and address, so we'll limit the order to that information. No, the order is for all subscriber information. And there's also some equally horrific misinformation about the tools the police currently have to do their jobs.
And what's unacceptable right now is it taking 6 months for the police to be able to get judicial authorization, to be able to connect a phone number to someone who's extorting an individual in my riding, who has been out of their home because their home has been shot up and it's dangerous for their kids to live there. They can't go to school in a regular routine. They can't operate their business, and that's unacceptable. And I believe in Canada, our law enforcement should have the capabilities of being able to track down violent criminals such as these.
I'm sorry. If it is taking the police 6 months to get a warrant after a house has been shut up, the police simply are not doing their jobs or are not using the tools they currently have. A police officer in a squad car can pick up the phone and get a production order if circumstances exist for dispensing with the formalities of a personal appearance before a justice of the peace. Now, the Honourable Ruby Sahota is the MP for Brampton North Caledon in Ontario. The local police of her jurisdiction is the Peel Regional Police. I've seen many production orders obtained by officers in the Peel Regional Police. I really doubt it takes 6 months of effort to get a production order. Most of them are issued within a very short period of time from the alleged offense. So just for illustration purposes, to find something on the public record, I did a really quick search in Public Legal Database and found a case from Brampton that will illustrate the current process. The case is called The Queen and Owen from 2017. The investigation began on March 23, 2015, of an unknown individual suspected of downloading images of child abuse. So they had an IP address connected with a suspected crime, but they didn't know who it was connected to. They obviously wanted the customer name and address. They could tell from the IP address who the internet service provider was. And so after some further investigating, the Peel Police sent a preservation demand to the internet service provider requiring the ISP to preserve the account information while they got the production order. So on April 7, they applied for a production order to get the customer name and address from the internet service provider. The order was issued the next day. Less than a week later, on April 17th, the internet service provider provided the information. 3 days after that, on April 20th, the police had a warrant in their hands to search the home. Now, I should note that the reason why the Owen decision goes into so much detail was that the production order and the search warrant were both thrown out because the police misled the court in getting them. But setting that aside, that's nowhere near 6 months. The laws in effect in 2015 are essentially the same laws we have now that the government wants the police to be able to sidestep. Suggesting it takes 6 months to get a production order is an outrageous statement from the Secretary of State for Combating Crime. It's so outrageous that I have to assume it's an outright lie. So here's what's in the current criminal code, which authorizes the cops to go to a judge and get an order for customer name and address, or frankly, any other information, if they have reasonable grounds to believe an offense has been committed and the addressee of the order has the data. What's proposed in Bill C-2 is an order based solely on a hunch, reasonable grounds to suspect an offense has taken place. They don't even have to believe an offense has actually taken place. And the scope of the production is much broader, fewer grounds and more information. Look, if the government thinks their proposal has merit and should proceed through Parliament, they should be prepared to actually justify the new powers. And they should do it with facts and not political puffery or even straight BS. I will assume, at least for now, that the Minister of Public Safety is being honest and in good faith when he acknowledges that the current bill is flawed, and when he says he's willing to listen to feedback to make it more acceptable.
It is not a perfect piece of legislation, so we are open to feedback from our partners, from civil liberties groups, from other entities that may have an interest in this area, and we will work across party lines to make sure that we have consensus on having a lawful access regime that is acceptable to Canadians.
I'll link below to my previous episodes where I discuss in some depth Parts 14 and Part 15 of Bill C2, in case you want the straight goods on what's actually in the bill, and so far nobody has accused me of making stuff up. I hope this has been interesting, maybe even useful. I try to put out a new episode every few weeks, and sometimes sooner if something riles me up like this. So if you're interested in this sort of content, please click the like and subscribe buttons. Also leave a comment if you have any questions, or if you have any suggestions for other topics to cover. And of course, feel free to share this with anyone who you think may be interested in hearing about Canadian privacy law. Thanks for tuning in.